going to begin our next panel. And the panel focuses on the role of government regulators and nonprofits in the enforcement of consumer rights. And I am Jeremy Lieberman. I am the managing partner of the Pomerantz Law Firm in New York, and we focus almost exclusively on securities class actions. We do a small amount of consumer and antitrust cases as well. And I'll just give you a few moments of our perspective on the issue, but really the stars here are the panelists who can give us a real international flavor on the importance and interesting topic regarding the government role in enforcing consumer rights. And so, from the U.S. perspective, I'll just we'll hear some more discussions regarding the Petrobras litigation. But just as an example, in the Petrobras case, it was a $3 billion settlement. Our firm served as lead counsel in the United States courts. In the United States courts, it dealt with Petrobras's. It was a kickback scheme engineered by Petrobras. It was the largest oil company. It was the largest oil company in South America, and it was a Brazilian-owned oil company, 51% owned by the Brazilian government. And basically, it was the mechanism, it was the engine of a great graft scheme concocted and executed by the Brazilian government. And the scheme went as followed. First of all, because it was owned by the government, it was basically the executives of Petrobras were all former government ministers and government executives. And the issue is that when you have that situation, it was basically a revolving door. You served as a minister of energy, you served as a minister of finance, you served in any other government capacity, you were almost ensured to be an executive at Petrobras, and vice versa. If you wanted to go back into government, the door was certainly open. And that lent itself to a lot of graft. And what happened was, over a course of more than a decade, Petrobras had engineered a cartel on its own. And the cartel was basically engineered to hurt its own business. What they did was they had about 20 construction companies that were able to construct refineries. And in order to do so, what they would do is they would say, okay, we're going to come up with a bid rigging system where they would increase the costs of the construction of the refineries by 20%. And it was known. Basically, they came out with a system a systematic system to rid the bids that every project would come in at 20% above cost. And what was done with that 20% increase? The 20% increase went 3% was given as a kickback. And the kickback went to two sources. One source was the Petrobras executives, of course. They got 1.5% of that 20% excess. And the other half went to the Brazilian Congress. You had 14 political parties in Brazil, and that's a very unruly way of legislating and of running a government. And so if you've got some money to kind of keep everybody in line, that might be a good way to help pass legislation. And so that 1.5% of every 20% overage went to government members and members of the Brazilian legislature and Congress who accepted graft and bribes and were involved in the scheme. Ultimately, as a result of the scheme, the company was forced to take an impairment. Their assets were overvalued by $20 billion because there was so much overpadding. In addition, 1/3 of the Brazilian Congress, as a result of their involvement in the scheme, was put in jail or arrested. Lula da Silva, former president of Brazil, was arrested as a part of the scheme as well. Dilma Rousseff, former president of Brazil, was impeached. And Michel Temer was the later president who succeeded Dilma Rousseff, and he should have been impeached because he was involved in the scheme as well. But by that point, the public was so sick of all these impeachments and all these putting everyone in jail. You have to run a country. They kind of gave him a pass, as it were, and did not vote. The Congress did not vote to impeach him. And now it's a new president who may have his own flaws and issues, but doesn't seem to be implicated in this scheme at all. And so the question we're asking here is, what is the role of the regulators in enforcing consumer rights? Here, in our case, it's shareholder rights. And the role is quite, I would say the regulator, in a way, could be a lifeline for a collective or class action, but also, to a certain degree, they're also somewhat flat-footed and behind the curve when it comes to enforcing these rights. So I think to take a nuanced view is on many fronts they do an excellent job in helping the consumer and the shareholder. And other ways they're a bit stodgy, as it were, and a bit inefficient in asserting these rights and bringing these claims to fruition. So in the Petrobras case, certainly as for plaintiffs, we benefited clearly from the investigation of the Brazilian prosecutors in bringing the action and in uncovering the fraud, and that evidence was critical in us proceeding with our case and building a very strong case against defendants and getting them ultimately to pay a $3 billion settlement, which was the largest settlement that ever was paid by a non-U.S. issuer. So it was the largest settlement by a non-U.S. company in a U.S. class action. So obviously they felt pretty compelled to give this money, or they faced an even larger judgments at trial. So on the one hand, the government agencies there did do a fantastic job. On the other hand, the SEC and DOJ didn't even bring a case against Petrobras until after we had settled our claim. And so therefore you see, and when the SEC finally did, there was finally a global settlement of about it depends how you calculate it, 1.6 billion or so, 1.7 billion. But they actually brought it after. It was less than the $3 billion settlements we achieved for investors. That's one issue. And actually, of the $800 million of the settlement, the $1.6 billion, was actually that they gave a credit to the company for contributing to our settlement fund. So you see, really, in the instance, the SEC and DOJ was kind of behind the ball when it came to enforcing investor rights in that action. I'll give you one more example in the U.S., and then obviously we'll turn it over to our august panelists. But we were also lead counsel in the Yahoo a securities class action. That case dealt with what was called the Siberian intrusion. That was there were Russian, could you believe it? Russian hackers hacked into Yahoo's database and stole information of about 3 billion customers. Yahoo had learned about it at the end of 2014, and while they knew about it in 2014 and were cooperating with the FBI, and there's an SEC regulation that says that you must disclose any data breach. But they didn't disclose it, and for 2 years, they didn't disclose the data breach. And not only did they not disclose it, even worse, to protect their customers, they had to do just one thing: ask the customers to change their password, and that would have, again, re-protected the customers who were then with Yahoo and their confidential information. And they didn't even ask their customers and their users to change their password after 2 years of knowing that there had been a breach. So they left their customers vulnerable for a full 2 years. Had the scheme actually come to light, ultimately, it was being sold on Yahoo, on the black market of the internet. I didn't know that there was such a thing as a black market on the internet. I'm not sure what the website is. If anyone knows, please let me know. But apparently they were selling on this black market 200 million passwords and personal information of Yahoo customers. And they were selling that, and someone approached Yahoo and said, "Is this really happened? Was there a breach? And is this information really the information of your customers?" And this is in about July of 2016. And Yahoo says, "No, that's not us. That's not us. That's not us at all." At the same time, they were trying to get involved in a merger with Verizon for about $3.9 billion. Verizon gets wind of this black market sale and starts to say, well, is there a problem here? And as part of their due diligence, they realized indeed there had been a hack, and indeed there was 3 billion users worth of information that had been stolen. And so it was pretty, in our view, pretty bad conduct by Yahoo, both to its customers and to investors. And so there was a settlement for the securities class action there of $80 million. And there, so you see, once again, after our settlements, the SEC settled for $35 million. So again, the SEC on that is once again kind of behind the ball, kind of working after the plaintiff's lawyers and the private litigants, and also recovering a lower amount of money. Now, there's certain legislative reasons. There's only typically the SEC is limited by disgorgement. And so that's a reason why the SEC can't recover these types of monies. But you see it's somewhat, the government agency's ability to protect the consumer is somewhat a mixed bag. They have, the power of the government is huge, and any corporation will tell you they're much more scared of the SEC and DOJ than they are of little old Pomerantz. That's definitely true, and that'll always be true. And any of our cases, if we're lead counsel in the class action and we hear there's a DOJ or SEC investigation, the value of our case has gone up, I would say, at least by 20 to 25% than it was before. So we certainly admit that. On the other hand, because there may be political considerations, because of other issues, we find the SEC and DOJ is sometimes really behind the ball in bringing these cases. For political reasons, they may not want to go after certain types of people. We've seen a lot of times Apple had been accused of various misdoings, yet they've never been really subject to an SEC action. They were actually involved in stock option backdating, which actually caught Kobe Alexander from Israel at Converse Technologies. But Steve Jobs did the same thing. He backdated his own options, yet there was no SEC investigation because you don't touch Steve Jobs. And so you can't always expect the government to really protect these wrongs and to act in the same way and with the same alacrity as a private plaintiff can. And so that's really kind of in our view, from the U.S. perspective, or at least from plaintiff's attorney's perspective, as the utility of these of the SEC and the government in enforcing the rights. They're obviously critical. They're obviously extremely powerful, much more powerful than I think a plaintiff's lawyer will ever be. But they're less nimble, and they move with less alacrity, and respectfully, because they may sometimes be less creative as well. A lot of times we've actually been called by the SEC, where we've been involved in a case and we've succeeded in convincing the court there's a good case, and they'll call us and ask us, well, what do you think about here? Is there a claim? Is this a proper legal claim? Is this really a material misstatement or something like that? And so sometimes there's a certain, when you're dealing, a bureaucracy is always has, in a sense, less flexibility, and that sometimes does, impair their ability to impact consumer rights. So that's the U.S. perspective, but we have, thankfully, really an excellent international perspective here at our august panel. And so I think we'll start with Professor Diogenes Carvalho, who is from Brazil, and he has a PhD in law from the Federal University of Rio Grande do Sul, a PhD in psychology, behavioral economics from the Pontifical Catholic University of Goiás, a master's degree in economic law from the University of Franca, and an associate professor at the Federal University of Goiás. So really, Professor Carvalho, we look forward to your words and really hearing from the Brazilian perspective how the government regulators impact enforcement and the Brazilian system in general. Thank you.
Good morning, everybody. It's very nice to be here. My name is Diogenes Carvalho. I'm from Brazil, and I'm a current president of Brasilcom, which is a national, multidisciplinary, non-profit and non-party affiliate organization of scientific, technical, and pedagogical nature. We are today reference in Brazil on matters of consumer law, and we also have an effective international role promoting national and international congress. We also have the best publication on consumer issues, the Consumer Law Review and Revista de Direito do Consumidor, coordinated by Professor Claudia Lima Marques, that already heard about this. And today I present this association, present this NGO, and the producers and the things that you can do like this. Here's Brasilcom. This institute was founded of the draft of the law, of the Code of Consumer Protection, the Constitution in Brasilcom in 1992. And since then, the entity has assisted in consolidation of consumer law in Brazil. Brasilcom has already supported, held, and participated in more than 100 events, congress, and seminars, academic and scientific activities, and updating and debating the themes that affect consumers, such as sustainability, responsible credit, economic plans, collective consumer advocacy, and all in all strengthening the national system of consumer protection. the quality of public services, and the international protection of consumer among our issues. This is the history of the Brazil Home about the Brazil Home became a reference for this academic excellence with this review and the quality of the intellectual protection. Became the reference. It also participates actively with the direct actions in unconstitutionality, such as ADI of the banks. It's the most reference in these associations. It's our ex-presidents and what? Brazil Commons became a reference for academic excellence with this review, Vista do Direito do Consumidor, the quality of the intellectual production. It also participated actively with the direct actions on constitutionality, such AEI of the banks. Here, our ex-presidents, Antônio Herman Vasconcelos Benjamin, is the founder of the Brazil Commons. Eláudio Becei, Cláudia Lima Marques, Clarissa Costa e Lima, it's our ex-president too. And our priorities today, you have this round of the directors. President, it's me, Diógenes Carvalho, two vice presidents, Leonardo Bessa and Bruno Mirage, and today have a director general secretary called Vitor Hugo, that's here today. And this structure effective channels of dialogue and articulation with the Brazilian system of consumer protection, including the civil entities, public prosecutors and defenders and PROCONs, and the state consumer complaints agencies. We also seek to effectively participate in regulatory processes, taking priority consumers protection guidelines to regulatory agencies, the effective performance in the inspection of conduct and rapid judgment of administrative processes in major causes. What defines our agenda? Today, the vulnerability of the consumer, the public policy, the cooperative practice, and the regulatory normal legislations, the fundamental rights and the threats to liberty. It's our agenda like this. The current priorities, approval of the bills numbers 3515 and 3514, which deal with the prevention and treatment of over-indebtedness and electronic consumer, the tourist consumer protection, the telecommunication and digital rights, and the implementation of the Brazil General Law in protection of personal data, effective action against abusive practices in these sectors. This is our, again, current priorities like this. You have numbers here about the Brazil Home. We have a representation on councils, commissions, and technical groups. We participate about 15 public consultations last years and audiences per year. We gave interviews and we replied to the different means of communications in Brazil. And another example of the associations in Brazil at the moment, we have historically another organization called IDEC, Brazilian Institute for Defense of Consumers, which supports the collective actions to defend consumers. For example, they manage obtain a stay against the government from authorizing the sale of the soya without prior evaluation of the risks of human health, environment impact study. Unfortunately, the government at the time liberated the production of the transgenic soil, but the IDEC is the biggest example in Brazil. The class action, for example, to oblige the financial institutes to replace the money taken from the saving accounts of millions of people by the stabilization plans of the ex-president Collor during a period of hyperinflation in Brazil, 1987 and 1992. I have here the numbers of IDEC 2. IDEC is the biggest association in consumer law in Brazil, representation councils and public consultations, and the class actions, the 360 class actions in Brazil from them. And we are still a long way from the European reality, due to the struggles of NGOs in Brazil, and certainly the pressure from these organizations like Brazil Call and IDEC that I spoke about earlier, which give a rise to public policies by the public authorities. And I think that in Brazil it's a different, we have a still long way from the European reality about this. Certainly. Okay, thank you.
Thank you, Professor. I would just ask just a brief question. If one were then to practically bring an action in Brazil, if he felt a credit card company had cheated him, what is very quickly, how would that be accomplished? How would the plaintiff bring an action to recover his rights, either on a collective or class basis?
In Brazil, you have the collective basis about, for example, in Brazil, just engagement the MXQ, and you have 14 process now, and I think that the class actions in Brazil, it's a long way because we have all of them. How do you say this in English? You have all of them. This probably it's so difficult for us because it's not the reality in Brazil. You have the new procedure law code and all of the rights and the bills that was constructing but news in Brazil. It was stopped now.
Mm-hmm. Okay, thank you, Professor. Okay, our next panelist is Dr. Maria Jose Zarbaud, who's the author of Collective Redress in France and Europe, Between Tradition and Modernity. Dr. Baud is a doctor in law with a double PhD from the University of Paris and Sorbonne and the University of Buenos Aires. She's an associate professor at the University of Paris, SUD, where she teaches consumer law, distribution law, contracts, comparative law, international law, and international sales. She's also a lecturer in business schools, namely ESCP, Europe, in bachelor's degree and master's degree programs. Dr. Zarbaud, please.
Thank you very much. And thanks to the European Organization Committee for the invitation. Congratulations for this great event. I'm honored to be here and to share this panel, this conference with prestigious professors and professionals. I must confess that some of you have been conclusive for me to choose in 1999 to dedicate my research to class action. So I deeply acknowledge them for their works and the influence they have on me. After decades of debates, seeking a virtuous model that would prevent the French system from the purported vices of the American class actions, France only enshrined a group action in its consumer code in 2014 to facilitate compensation of individuals in mass harm situations. Notwithstanding, they have been scrutinized, hard criticized, as the scope, standing, and remedies were rather restricted. Firstly, the device only addresses consumer disputes and certain consequences of anti-competitive practice. Secondly, only as a In terms of registration, years of existence and public activity, only 15 up to date, can introduce a good action. Finally, compensation can only be sought regarding material damages leaving aside moral injuries. Expanding the range of group actions became indispensable, therefore they mushroomed in different fields. First and foremost, the lawmaker has enacted group action in the field of public health to guarantee the enforcement of the right to compensation for personal injury, namely physical and psychological integrity. Then, the law for the modernization of justice for the 21st century enacted 3 more group actions in the field of environment, discrimination and data protection, as well as an action for the recognition of rights. The former can be introduced both before judicial and administrative jurisdictions and address both injunctive and compensatory purposes. The discrimination-related group action aids to guarantee the right to non-discrimination within the scope of working relation and public service. The environmental group action goal is the enforcement of the right to take compensation of material and personal injury resulting from a purely ecological damage. And the personal data-related group action seeks the termination of infringement of the Trade Data Protection Act and compensation of harms caused by the same misconduct. Last, the primary action for the recognition of rights is engaged before the administrative justice and the regulator can only declaratory. In favor of an unidentified group of persons, it pursues the recognition of individuals' rights arising out of the application of a law or a regulation so that the compensation of damages cannot be sought. We consider French group action has become a precious procedural tool to enforce and strengthen the effectiveness of the citizens' rights. Nevertheless, the system being sectorial, group actions remain locked to the protection of rights having been awarded in group action. Therefore, new reforms in the field of group actions keep rising, as illustrated by the recent law expanding the scope of group actions to the field of housing. This situation seems to create distortion in the enforcement of the other fields, such as human, social, economic, and cultural rights, which may share the same typology when they belong to a group of individuals and are homogeneous and thus justify a collective proceeding. Nevertheless, from the consumer point of view, addressing this panel, one may say that overall, the system operates in the enlargement of the consumer definition and the happier approachment of it with the citizen are the litigant. Indeed, the different devices are offered to natural persons such as consumers, victims of infringements of their data, and also to legal persons in the environmental actions. Moreover, group actions came out under an array of additional devices that have been in place for several decades. For instance, the Consumer Code provides for 4 types of collective actions addressing the cessation of bad practices, the elimination of cartels, in consumer contracts, joint employment actions, and the action for the compensation of damages caused to the collective interest of consumers. The latter has been defined to the defense of the collective interest of the environment, victims of sexual offenses, children, animals, and investors. The joint actions, the action of representation conjointe, has also been expanded to include the name of victims of damages pertaining to environmental concerns and security. All these proceedings really goals which are different from the compensatory collective redress for certain actions, except for the example of the representation conjointe, in as much as theoretically, it also addresses compensation of similar injuries sustained by several persons placed in same identical circumstances. Conversely, the conditions set out by the lawmaker in 1992 rendered the mechanism completely useless, so that group action had become, the need of group action had become crucial, thus advocated both at national and European level. Furthermore, France has wide experience in the creation of ad hoc compensation funds, targeting a particular damage, namely those suffered by victims of terrorism, medically related incidents, and asbestos. In this nebulous context, several internet platforms have flourished to gather individual, more classic joint actions, which from an entrepreneurial point of view seem a success story. We can discuss it later if you want. Likewise, civil society is involved developing marketing tools to raise awareness, which ultimately trigger new ways of acting collectively. For instance, 4 NGOs have launched a campaign called the Centuries Affair a few months ago to gather signatures for a petition to force the government to act against climate change. After collecting more than 2 million signatures, on the 14th of March, they introduced a request before the administrative court to declare the state's inaction for 40 years as illegal. Whereas some countries, like Argentina, where I come from, have a wide experience in this field, we will see how French judges will rule this affair, as this could be the first structural litigation in France. Even though more than the enforcement of rights, trials likely to be focused on the eventual overlapping of separation of powers. All the above mentioned devices coexist, but they do not seem to be a source of efficiency. The lack of coordination and of articulation amongst them can be spreading and flows and system considered as a whole. Maybe the answer to this mysterious situation is to be found in the features of the proceedings of transactions. So to understand please some of the features of French group actions. A common framework was enshrined in the rules of the Code of Civil Procedure and the Code of Administrative Justice to regulate discrimination, environmental, health, and personal data-related group actions, leaving aside consumer and competition ones, which remain provided for in the substantive litigation, even if the proceedings are quite similar. In all the cases, the procedure follows a multi-stage process, dealing respectively with the liability, the opt-in, and liquidation. The process can be sometimes of spoilers. Before the initiation of a group action, the person having standing to sue must address an out-of-court prior formal notice to the person allegedly liable, requesting the eventual defendant to cease legal practice or the same damages to the group or to both ends. Then, a period of time, usually 4 to 6 months, needs to be observed. Should the recipient fail to satisfy the request, the lawsuit can be introduced and must include oral cases on the basis of which the decision will be granted. In a decision dealing both with the admissibility, justification, and the merits, the judge may order the cessation of the practice in question or the compensation by holding the defendant liable towards the group. Consequently, the judge defines the connecting factors to the group so that they can identify and obtain the damages concerned, and triggers the advertising period, after the end of which the opt-in stage is opened. Victims belonging to the group and meeting the requirements described by the judge should join the group through an application addressed to the claimant or to the defendant, and within the time limit established by the judge that varies according to the field of the group action. 2 to 6 months in consumer protection, 6 months to 5 years in health public group actions. The defendant then proceeds on to an out-of-court individual compensation. Should he fail to do so, a third enforcement stage is engaged. Consumers whose application have not been acknowledged may refer the matter to the judge through the association for the liquidation of their damages so that they do not appear in courts. In the other group actions, 2 other systems of compensation are adopted, and we can discuss them later if you want. So this long-pondered French group action introduces an unprecedented device, placing France amongst the European member states endowed with a sort of collective compensatory redress, whose features unveil the strong influence of the European Union. It's noteworthy, according to a study of the state of the art in the European Union, I met with colleagues last year for the European Parliament, that some member states do not have a collective redress mechanism yet. Nevertheless, the French system seems rather inconclusive. According to specific data collected by the Observatory of Group Actions, which I set up to assess the outcomes of these various reforms, less than 15 modern group actions have been engaged before the judicial jurisdiction and around 20 before the administrative one, while the classic collective actions, mainly injunctive, continue to be exerted in parallel without any articulation. But to conclude with a positive tone, one may say that France has settled an original system which is a mixture of tradition and modernity, like the country we're in, wherein joining the group does not involve any risk for the members of the group, inasmuch as it takes place after the courts have stated the professional's liability. Nonetheless, from an economic and behavioral analysis, other conclusions could be drawn, as the person likely to join the group would act differently when the individual harm is lower, equal, or greater to done expected within the scope of the group action lawsuit. In the former case, to be compensated, the persons would better join the group, whereas in the latter, they have no interest in joining the group, as the suspension of the limitation period of the individual action incentives the claimant to wait for the outcome of the group action and to use the informal authority of res judicata when the decision is favorable to the group. This situation can be described as a sort of second chance right, likely to impact negatively on decreasing the rate of dispute, which is, I deeply believe in, one of the objectives of any collective redress, collective compensatory redress. This is yet another limb of group actions to be explored in France. Thank you for your attention. I'll be glad to answer to any questions or comments.
Thank you very much, Dr. Azarbaud. Our next panelist is Professor Geraint Howells, who is the Dean and Chair of Commercial Law at the City University of Hong Kong. He has taught and written extensively on topics such as product liability, fair trade, consumer safety, and European consumer law. Professor Howells, maybe you could give us your perspective on the UK system for consumer redress.
Okay, well, thank you. I'm very nervous now because, as you said, I've been away in Hong Kong for 5 years and doing administration rather than following class actions. And also, I know there's people in the room like Augusta and Ingrid and Ulrika from Austria who are more up to date on the position in the UK and Europe than I am. And in my defense, I thought Hans Mikkelsen was going to be here and we're having a roundtable discussion. I could have just supplemented some of Hans's comments. Working? Yeah. Okay, I won't repeat everything I said because it was just introductory. But myself and Hans worked for several years with BEOC on a project which was about empowering European consumer groups to make use of the considerable substantive European law to try to bring it into action. So I think I can be fairly brief because I'm not, as I say, I think the points I make can be discussed better by others. But on this topic, I would make a few points. First of all, what came very clear to me was that consumer organizations, in the first instance, if they're going to bring these actions, they need to have incentives to do so. Those incentives don't need to be recovering a lot of money themselves. In many cases, it could be a member service. If you can show that by being a member of the consumer organization, you have access to legal service, which can provide you with redress, that can be a positive benefit. But in some cases, of course, they are incentivized by the idea that they can actually recover some money through CPRA schemes. Of course, the logic of that is a bit complicated to work out because if it's happenstance that there's some money left over that people don't claim, or possibly you can think of a different basis for those damages. The French have a very interesting concept of damage to the consumer interest distinct from the damage to the individual consumers. But the problem is that in France, whenever you award that, you only award €1. So it's an interesting theoretical concept, but not really practical. So I think that's one issue. We need to think about if you really want consumer organizations to be the gatekeeper, and that's part of the logic of the European model. They don't want the American wolves coming into Europe with the lawyers. They want to have a different model, a more sort of sanitized model and a more control over it. If you want the consumer organizations to be those gatekeepers, you've got to give them some incentives to do so. But then the problem is that you have to go back to the wolves to actually finance the litigation. If you look at consumer organizations, they need to get somebody to provide the legal expertise for them. They either outsource it to private practice lawyers, as I think they do in Austria, or they work on a sort of contingency fee, but Ulrike can tell you more about that. And I think when Which did it, it was pro bono lawyers who took the football shirts case in the UK. So there needs to be some model of financing the consumer organizations. Actually, Hong Kong, if I try to show how being Hong Kong can help even the Europeans, has quite an interesting idea of a consumer legal action fund. And this isn't really for class actions as such, or it could be adapted to it. It's a fund set up initially with a government grant, which is then administered by the Consumer Council, and consumers who want to bring legal actions can go along to it, and under fairly strict conditions, which means it doesn't work as well as it could, get access to funding where they wouldn't be able to under the legal aid system, which in itself is very well funded in Hong Kong. And in return, they pay a percentage of the recovery back into the fund. And I would much rather a system where the top slicing of the damages goes back into a fund to help future litigation than goes into venture capitalists. Sorry, venture capitalists in the room. But I think my general tendency is that we should try to make the legal system as cheap and seamless as possible. And in fact, we had a conference just the other week in Hong Kong on no fault for accident compensation, and that was in part because we wanted to try to make sure as much of the compensation as possible got to the victims' accidents, and equally here in the case of consumers, I would say we should make sure that as much of the compensation gets to the individuals as possible.
So, Professor Howells, speaking about the wolves, I guess that might be me. I must be the wolf at the table, being an American class action lawyer. But talking about costs and issues regarding that, and so the European system doesn't want to, as it were, let the wolves in. In the Petrobras case with $3 billion settlements, the cost to the class was about 6.3% of the class recovery. And so the wolf was let in, and the wolf was compensated, but it was much cheaper than the system that is keeping the wolves out. And so how do you kind of balance that?
Well, I mean, I think there's a range of cases where you can look at where class. I mean, I know people know this better than me, but a range of cases where people could show that the costs were relatively low. You look at the tobacco litigation where the costs were relatively high, and you had people claiming fairly large compensation who the other lawyers said they never even knew they were involved in the case. So, I mean, it may be just that we have to sort of shake out the system and make sure that it works effectively, and that these sort of stories which get around and spoil the reputation system are driven out of it. Mm-hmm. I mean, certainly I think what I would say is interesting about the American system is that it has achieved certain things which the European systems just have failed to do so. So I was doing some work recently on artificial hip litigation, and there you see settlements in America which are taking place, which are just being lost in the UK. So you've got to ask yourself, how can one system manage to provide redress and the other abjectly fail to do so? So I think there's a lot of strengths in the American system. What I'm saying is that at the moment the European system isn't geared up or willing to accept it in its full form, but actually in many ways it may be getting in through the back door. Yeah. For sort of the way these cases are financed, not directly but through indirect means.
Great. So, well, thank you. Okay, our next panelist is Augusta Martier-Vloet, who's a team leader and a senior legal officer at the European Consumer Organization, the BEUC. She's working on issues related to enforcement, collective actions, and alternative dispute resolution. Augusta holds a degree in law as well as a master's degree in European law. and she has been studying European law at the University of Aix Marseille in France. Augusta, we'd love to hear your insights on this matter.
Thank you. Hello, everybody. First of all, I would like to thank the organizers of inviting the representative of consumer organizations. Thank you very much. I will talk about the barriers that consumer organizations face when they bring collective actions, and whether those barriers might be addressed by the new pending legislation in the EU. But first of all, if you allow me a short comment about the role of the regulators in securing redress for consumers. Because already in a couple of European countries, the regulators have this power. I know for sure that it exists in UK for several sectoral regulators. It used to be also the case in Poland. But some of those regulators do not use it, others use it quite successfully. And there was an attempt, actually, in the European Union to give this power to all the national consumer enforcement authorities, the public authorities, because there was a review a couple of years ago of one regulation about enforcement of consumer law. And the European Commission put among the powers of authorities the power to order compensation for consumers. And the authorities did not like this idea at all. They said like they are not well placed to do that. They don't want to be evaluating the damage to consumers because that will mean they will take much longer in investigating cases, and they might be then maybe, you know, the decisions might be appealed more often. So actually they have taken it out of that proposal, so finally it was adopted without this power. So for some reason, public authorities do not like the idea at all, and we stay then only with, well, private bodies, if you want, being able to, or trying to secure redress for consumers. So some of the barriers that our member organizations face in the countries where there are national collective redress procedures. First of all, the information to consumers, and especially in opt-in cases, is often very burdensome and expensive. For instance, in one of the recent cases in Italy, our member Altro Consumo, they were ordered by the judge to place information about opt-in for consumers in 5 Italian newspapers, which apparently was not efficient at all because nobody reads those newspapers any longer. So of course the Italian organization then they did it through social media and, you know, used their own avenues, if you want, but they were still obliged to spend more than 130,000 euros just for those advertisements that were not efficient at all. So, and in quite a number of cases, the trader already has, for instance, the list of their clients that they could use to inform consumers. So actually, in the European proposal, there is a provision now that will enable the court to order to require the infringing trader to inform consumers at its expense, and where appropriate, even through individual notifications. Of course, it's still pending, so we don't know if it will go through, but the European Commission made a note that this was complicated. So, another barrier is obtaining the evidence. which is especially complicated in follow-on actions, because then it brings the redress action quite far away in terms of time from the infringement, and most consumers, they do not save any kind of receipts or anything, especially if they don't know that there has been an infringement and that they might be due compensation. Under the older system in France, there was an antitrust case that actually failed. But the thing was that the consumers did not have proof that they were clients of the telecom operators who were found to have had a cartel agreement. So consumers then went to those operators to ask for the duplicates of the bills, and the operators asked enormous amounts of money for the duplicates. So that can happen, and also in general it's quite complicated to somehow inform consumers in advance that they should keep evidence. Or nowadays, many consumers would not even have the product at hand if it's something that you use more quickly than, for instance, an action, a competition action takes place, or if there are a lot of appeals. So it's a difficulty. And in general, as we know, there is a quite imbalance of how much information and evidence the company has, and how much of this information can a consumer or their representatives obtain. So indeed, again, in the EU proposal, there is an article that will make it slightly easier to obtain evidence. And my last point is maybe the most important one in general, about the funding of collective actions. So of course this is the most difficult point because without the funding, usually consumer associations cannot bring any actions at all. Unfortunately, there is quite a big controversy in the EU about third-party funding and contingency fees, and many member states would like to prohibit both options. European Parliament was also very cautious on both points, whereas the European Union proposal, as already mentioned by Professor Stadler, was quite balanced, if you want. I mean, there were restrictions for the third-party funding, for sure. But then also the European Commission proposed that, that member states should somehow ensure that, that procedural costs do not create barrier for collective redress actions. In this sense, EU countries could decide to limit applicable court or procedural costs, grant access to legal aid, or even provide public funding. As far as I know, but this is not printed anywhere, most member states find it unacceptable. So there are low chances that these assistance provisions will remain in the actual legislation when it is adopted.
Okay.
Thank you.
Well, thank you, Augustine. Do you think that it seems like funding is a big concern for launching these actions? Would allowing a contingency fee to a lawyer to represent the contingency fee wronged consumers or investors? Wouldn't that maybe solve a lot of the issues and lower costs for the representation? At
BOOK, we don't see it as extremely controversial, because indeed we believe that for consumers, well, depending on how high is the fee, could be better to get 80% of the compensation than zero compensation if there is no action, right? So, but our opinion there, let's say, is not the prevailing one.
Okay. All right, thank you. Our next...
You would think, but maybe the member states, the EU countries, maybe they don't so much want to have collective actions being brought. No, because they just want to limit everything.
Okay.
Yes.
Our next panelist is Ingrid Gubai, who's a partner at Hausfeld LLP in the UK. And I know Ingrid is a last-second panelist, so I'm going to ask her a question, hopefully make it easier for her. And then I want also all the other panelists to answer the same question. And we have about 10 minutes more, so we'll give everyone about 90 seconds to answer the question. Is this fair, Ingrid, or no? The question is as follows. It starts with the assessment that in the US you have 3 ingredients to a redress for consumers in a class action. You have opt-out litigation, that unless you opt out of the case, you're automatically covered. You have a contingency fee arrangement as well, and there's no adverse costs. And so my question to you is, it appears to me that this is the reason why the US, the recoveries are so much larger, where you're able to get a $3 billion settlement, where there's less transactional costs, and where there's more flexibility. Part and parcel of that is that you are letting the wolves in, which seems to be a very big issue. And so the question on each of these 3 issues, Ingrid, is do you think these should be applied in the UK? And if so, why? And if not, why not?
Okay, thanks, Jeremy, for your question. I'm just going to tell you that I was thrown onto this panel at tea break. And I'm not Hans, though I'm starting to feel like him and look like him. And I'm not Which, which was the other reason I'm put here. And I'm not representing the views of Which, though we are going to come to private enforcement in a minute. As to Jeremy's question, look, I think everybody in the room would agree that the proposition in the States, low cost to consumers, everybody gets something, contingency fee, if it's reasonable and proportionate, everybody would see that as fairly idyllic compared to, fiascos in the VW case, for instance, which showed the huge lack of parity and the inability to bring these cases. So, I and Augustine and others would agree that that's where we need to get to on these questions. So, Jeremy, are you happy that the US system, at the moment, when it comes to these big mass class actions, product liability based, fairly small value claims, has the upper hand at the moment?
I'm happy, I guess, to be practicing in such an environment. I think I'd rather that the entire world adopt that system. It would be easier to practice everywhere for everyone. So I don't know that I feel so great about it. I'd rather the best system be promoted everywhere.
I would agree with that.
Yes. So how about you, Professor Cavallo? With these three ingredients: opt-in versus opt-out, contingency fee or not, and no adverse costs. Where do you come out on them?
No questions for me. In Brazil.
Brazil, yes.
Yeah, in Brazil, you have, for example, in code of the consumer code in Brazil, you have the 3 difference of these kinds of, for example, how do I say litispendency? The individuals don't dependence for the class actions, and the consumer have to opt in to do this. This is the system, actual system in Brazil.
Right, Dr. Zabaud, on these 3 issues, where do you come out? What should be the system?
As for the third question, loser pays applies in France, and contingency that frightens consumer associations. So that's the main reason why we only have 15 group actions before the judicial jurisdiction when we are celebrating the 5th year of the group action in October. As for the contingency fees, we always say they are prohibited in France. In fact, they are not really prohibited. They are only authorized if the lawyer has been paid in advance. Lawyers cannot work for free. That's the main difference. And then we can have a pacto de quotalities. And pertaining to the question of opt-out and opt-in, well, France has adopted an opt-in system, as I tried to make it clear. However, the res judicata is some kind of secundum and eventum litis, like in the Brazilian system, as judicial judgments only bind members of the group who have been compensated. But we do have a very interesting rule in the Code of Administrative Justice, so for the group actions opposing the state and the group, and we do have 20 of them, which is much better, as it has established new dismissal subsections concerning res judicata, because the judge can dismiss a group action when the individual one coming afterwards leans towards the same end, and when the latter could have been eligible for the rejected group action. So it's very, very interesting, because it says sort of erga omnes res judicata, even if it is negative. So some kind of two-way preclusion. But we have to read carefully to understand this, because we speak much less about administrative group actions than judicial ones.
Professor Howells.
Yeah. I'll concentrate on the third one, the adverse costs order, because under the old-fashioned legal aid system in the UK, people in receipt of legal aid were basically immune from having to pay the other party's costs. And I think that the model of the consumer organisation as a gatekeeper is one way in which we can perhaps move that debate on, in a sense that I don't think you'll get a wholesale reversal of the cost order structure, but you could argue that as long as the certification case goes through some scrutiny of merits, there's arguments to say that consumer organisations should benefit from no cost orders. And so that's one positive benefit of the gatekeeper approach, and possibly one way in which you can encourage litigation.
Great. And Augusta?
I will then mostly comment on the opt-in and opt-out, to say that we very strongly support opt-out, because we see clearly in the cases that our members bring that in opt-in cases, usually it's less than 1% actually of consumers who opt-in, especially if it is the opt-in in the very beginning of the action. I'm not speaking about the one in France that is, if you want, delayed. But for instance, we have two cases that are quite similar against the national railway companies. So one in Italy, where actually the infringement caused damage to more than 700,000 consumers. But as it is an opt-in system, only 6,000 have opted in, so that's less than 1% indeed. In a similar case in Belgium, the court allowed opt-out action, and all 44,000 of consumers finally were compensated. So with the examples, you can very clearly see the difference. Thank you.
Great, thank you very much. And you know, there's a song in the U.S. I hope you've never heard of it. It's called, and the phrase is, "Who let the dogs out?" So the question might be after this panel is, "Who let the wolves in?" But I hope. Thank you very much to the panelists for your participation. It's been very helpful and very informative. And most importantly, we have lunch outside, and for everyone to participate and enjoy and mingle as well. So thank you very much.